My name is Roma Mandal. I'm head of the International Law Programme here at Chatham House. And we're delighted to be hosting this evening's meeting on strategic litigation for social justice with the Open Society Justice Initiative. So welcome to Jim Goldston, who's come from New York to join us for this discussion. So we're going to be looking at the growth in strategic litigation globally and asking ourselves the question, what has been the real impact on reform, whether that be social, legal, or policy? And to take us through these issues, we have a very experienced panel of litigators. If I start with Jim on my right, Jim is, as I mentioned, the Executive Director of the Open Society Justice Initiative. And in that role, he oversees the litigation that that initiative carries us out globally and the support it gives to others involved in strategic litigation. We also have with us Lucy Claridge, who's recently joined Amnesty as its Director of Strategic Litigation, so the clue is in the title, I guess. And previously, Lucy was the Legal Director at Minority Rights Group International. And we're also joined by Mandira Sharma, who was the co-founder of Advocacy Forum, which is an organization of human rights lawyers in Nepal that works to represent victims of Nepal's civil war and more generally on legal reform, I think. Yes? So what we're going to do is each of the speakers is going to sort of provide us some observations from their own experience for about 10 minutes each. And in Jim's case, you're going to talk us through the research that OSJI has conducted over the last few years on the impact of strategic litigation. And I think we have some, yes, there, copies of the executive summary of the final report if you would like to take one before you leave. After Jim, I'm going to ask Lucy to tell us about her work with MRG, I think, in land rights cases in Africa. And then we're going to hear from Mandira about the litigation she's conducted in Nepal, as I mentioned, on torture and other sort of civil rights issues. So after that, there should be about 40 minutes where we really would like to hear from you, any questions that you might have for the panelists or any observations you have yourself from your sort of involvement in strategic litigation or activism generally. I think there's only one or two more things I should mention. Well, probably I should mention is that we are not under the Chatham House rule. And yes, so be warned. And even more than that, I think we are being video captured so that this event can go on to the Chatham House and the OSF website. So everything is on the record. That's it, I think. So Jim, if you're happy to start.
Thank you, Ruma, and I want to thank Chatham House for convening this discussion, as well as my colleagues Lucy and Mandira for participating in it. And I'm going to talk about the reports, but I want to put them in a context, if I may. At a time when illiberalism has become a badge of honor for many, it may seem perverse that the Open Society Foundations would dedicate precious human and financial resources to the long, uncertain, and often frustrating project of strategic litigation to advance human rights. After all, the ideals upon which litigation is premised, including respect for the rule of law, impartial fact-finding, the principle of legal accountability, are increasingly questioned, if not disparaged, as unnecessary hindrances of the popular will. And yet the Open Society Justice Initiative, one of the larger in-house foundation legal centers in the world, pursues litigation precisely because we believe that law plays a vital role in preserving and strengthening open societies. In a world of increasing political intolerance, courts are often among the few spaces where power may be challenged, dissent voiced, and independent scrutiny applied. Now, while all interactions with official actors and institutions test society's commitment to the rule of law to some extent, I think litigation is special On the one hand, court proceedings are formal affairs imbued with the full authority of the state. Secondly, judicial decisions derive their legitimacy in part because they're grounded in evidence and transparent reasoning, not simply ideology or political preference. And while legislation speaks in the general language of policy, it's through litigation, the crucible of a concrete case or controversy, that the implications of legal provisions are critically examined as they manifest themselves in the practicalities of real life. Now, before we, or at least I, get too carried away with our own virtue, we must acknowledge that not everybody sees strategic litigation in quite so rosy a fashion. To the contrary, it has a pretty poor reputation in some circles. It has been said that litigation is too time-consuming. We need results now, not 10 or 15 years down the line, which is how long some judgments have taken. Litigation, it is costly. As a result, it primarily, it is said, serves people and institutions with the resources to pay. And no amount of public interest funding, and there is all too little available, can overcome that vast disparity. Because litigation is so time and resource intensive, some complain that it diverts valuable resources from what would be more productive activities: organizing communities, marching in the streets, running for public office. But time and cost are not the only problems that skeptics of litigation point to. Litigation, it is said, exists to serve the interests of lawyers, not people. Think about it. Rights litigation often doesn't happen organically because ordinary people think of it on their own. It happens often because lawyers advertise their availability, and all too often they litigate for the wrong reasons, not because litigation is the best choice of action, but because that's what they know how to do. Litigation, it is said, is technical, driven by judges and lawyers. It disempowers communities into thinking that lawyers have the answers and not they themselves. A final problem that people point to is that advocates for litigation often understate the risks of negative consequences. People talk about the value of powerful precedent to advance the law, and that is very true. But a number of people point to the harm of negative precedent. And one case I think that's worth noting from the American experience is the converse case from Brown versus Board of Education. Now, folks will be familiar with the example of Brown versus Board of Education as the mid-20th century icon of strategic litigation that expanded rights for African Americans and made clear that they were equal members of the political community by striking down this nefarious doctrine of separate but equal. But that nefarious doctrine was established back in 1896 in a case that was a strategic litigation case brought to address segregation, which failed and left a landmark decision on the books that took 58 years to overrule. So critics raise a number of questions and concerns about strategic litigation. In order to help get beyond some of the polemics, the Open Society Justice Initiative embarked 4 years ago on a series of studies trying to look at what impacts litigation has in fact had in a dozen different countries on 4 different themes. One set of studies concerned the rights of Roma in Czech Republic, Greece, and Hungary. A second study looked at equal access to quality education in Brazil and India and South Africa. A third looked at the question of indigenous land rights in Kenya, Malaysia, and Paraguay. And a fourth looked at the challenges to torture in Argentina and Kenya and Turkey. And as Roma mentioned, the executive summary of a report still to come that is going to be distilling the findings of these reports is available here. Now, why did we embark on this study? In part out of pure institutional self-interest. The Justice Initiative engages in litigation around the world. We want to know to what extent there is value and impact from what we're doing. Open Society Foundations is a major funder of litigation around the world and has a real interest in knowing what value it's getting. But there's also the broader interest of the field. We're not the only ones asking questions about strategic litigation's value, and we wanted to take seriously some of the concerns that have been raised. There are, of course, many studies that have been done about impacts that are really primarily for litigators, but this body of research was designed broadly for the field of social actors who might be thinking about how can I bring about change in the field in which I'm working, and within the range of tools, where would litigation fit among a more comprehensive set of strategies. Our goal from the beginning has been to carry out the studies together with actors who are practically engaging in advocacy and various other activities in furtherance of social change. So the end result is not so much a scientific study, it's a qualitative socio-legal inquiry that's based on hundreds of semi-structured interviews with people who were involved in struggles for change in particular issues, in particular places. Now, what do we mean by strategic litigation? Litigation, we're talking about advocacy taking place before judicial officers who are applying or intended to apply law to facts. Strategic can connote many things. For us, we're talking about cases that were designed or have come to assume the purpose of achieving some change above and beyond that for the individual claimants before a court, that has some aspiration to a broader policy or social change. Often, but not always, these cases may be chosen carefully, self-consciously, with some notion of deliberate forethought, the concept of strategy. And often, I think ideally, they should be pursued in recognition that litigation is one tool among many that are needed to work in concert to achieve change. Now, not all litigation is impactful. The Plessy case I noted is one, but there are many, of course, that are not. And not all impactful litigation is strategic. There are many impactful cases that started out simply as an effort to seek a remedy for an individual person or group of persons, and its implications more broadly happened over time. So let me, with that preface, just turn briefly to the main highlights of what the studies have shown. First of all, as to scale. Despite the many concerns that are being raised, there seems to be no indication that strategic litigation is slowing down. Over the past quarter century, common knowledge tells you, and the stats support it, that the numbers of cases filed before the regional human rights tribunals, before UN treaty bodies who deal with these questions, are on the increase, such that a number of them are suffering from tremendous backlog. I think that's true largely at the national level as well. And what is striking about national level litigation is how much of it is taking place in countries that don't come from a common law tradition, and how many new organizations have been created in the last quarter century who have a primary or exclusive focus on litigation in civil law countries from Kyrgyzstan to Senegal to Brazil to Lebanon and beyond. If strategic litigation was ever an Anglo-American phenomenon, and I think that's in part a myth, it certainly no longer is. A second insight I think we learned through this set of studies is that the most compelling evidence, or one of the pieces of evidence, of litigation's impact is the extent to which governments and powerful figures who are often its targets have gone to criticize or short-circuit or silence it. It's precisely because legal action can annoy or embarrass or compel redress or policy change that many of those who are its targets have come to criticize it. Now, folks here will recall David Cameron's comment that the Strasbourg Court's judgments on prisoner voting rights made him sick to his stomach. In the United States, Donald Trump, of course, more recently has attacked judges who dared to challenge his immigration bans on persons from Islamic countries. So in its opponent's eyes, strategic litigation appears to matter quite a bit. Thirdly, strategic litigation, we think, is best understood as a process rather than as a single binary outcome. Many points along the process have significance, from early on, before any case is filed, discussing with relevant actors where litigation might fit in, what the costs and benefits might be, all the way through to judgment, to beyond, to affecting implementation of what has been ruled from a judicial decision. So strategic litigation is a means to the end of change rather than an end in itself. Fourthly, litigation can have many different kinds of impacts, and they seem to lie along a spectrum from the material to the emotional and psychological. And the study examined 3 categories of impact. First of all, at one level, legal action can produce concrete changes for individual petitioners and affected communities, more books for schools, compensation for torture victims, transfer of land ownership, things that are tangible that can be seen and felt. At another level, there can be policy impacts, new institutions created to monitor implementation of a judgment, changes in jurisprudence, the adoption of administrative regulations and legislation. And most intangibly, but in some ways most powerfully, litigation can generate impacts on discourse and attitudes, whether empowerment of communities, recognition by the general public that there is a problem, or the satisfaction afforded an individual claimant of having officially confirmed a personal narrative that has been denied. Fifth, the impact of strategic litigation is generally maximized when it is married with other tools and rooted in a more comprehensive strategy of change. Indeed, whether litigators and individual plaintiffs or social activists should initiate a case is often less important than that they act in ways that are self-consciously and mutually reinforcing. Often, the strategic choice is not to go ahead and sue, but rather to pursue other avenues to change. And there are examples that we have mined about that. Sixth, litigation is often not a one-off process. Sometimes its impacts are iterative and incremental as one case or a series of cases builds on one another over time. One example from the study, in Argentina, some of the first cases brought to redress abuses under the dictatorship of the 1970s and early 80s encountered judicial reluctance to overturn a general legislative amnesty. And yet those cases, while not immediately successful, did lead to the disclosure of facts about specific abuses. And the fact that those facts have been disclosed over time affected public opinion. In parallel, lawyers who could not go to court in Argentina but pursued cases in other countries, in Italy, in France, and Spain, about what had happened in Argentina, yielded rulings which further contributed to discussion such that by 2001, 15, 20 years later, the climate had changed such that Argentina's own courts were finally ready to overturn the amnesty and open the floodgates to hundreds of prosecutions for human rights crimes. Final point. While lawyers, of course, have a key role, strategic litigation is and has to be about more than lawyers if it is to have enduring impact. I think our sense is that, and I mentioned that at the beginning, the study was done very much in partnership with social change actors. I think that is one of the key insights that we got from this, that marriage of partnership, the recognition that litigation often plays a modest role, if an important role, is one of the most important we came away from. Our sense is some lawyers really get that, and others, I think, still may have something to learn about that. So thank you very, very much. Look forward to the discussion.
Thank you. Thank you, Jim. So we've got a lot to think about. And before we turn to Lucy to give us a kind of a specific example, we're going to watch a very short film that was put together by Minority Rights Group. It's about 4 minutes, and it's about the land rights, or a particular land rights case in Kenya. Yes? Okay, it's a while since I've seen an uplifting film on the screen here at Chatham House, so that makes a nice change. Tell us more.
Thank you, and thank you very much to Chatham House for convening this event. So I know I'm biased. I know I was involved in the OSJI case, but hopefully that film has given you a little bit of an insight, possibly more in 4 minutes than I can say here now, as to the potential immediate impact that strategic litigation can have, particularly on the behalf of big communities like the OSJI. So I hope to share some insights now into the way that litigation can create impact, drawing in particular on my experience working with indigenous communities like the OSJI and the Endroys in Kenya, who feature in the OSJI study on indigenous land rights, but also maybe identify a few areas for growth where litigation could be supported and where there could be some other lessons learnt. So the first thing to say is that strategic litigation, as seen through the eyes of lawyers, is not always strategic for communities or claimants themselves. So the Ogyek case, for them, did not begin as strategic litigation. As you've seen from the film, they started this struggle way before they came to MRG in 2009. They'd had nearly 20 years of litigation in domestic courts unsuccessfully. They'd also tried to challenge their evictions and their treatment through advocacy over a number of years with no success. For them, approaching MRG was actually more of a last resort. But then strategic litigation actually became extremely important in the struggle. Because the African court case, as you've seen, lasted for 8 years. So it required unity. It required a common voice. It's a huge community numbering 30,000. They live in scattered locations throughout the Mau Forest, and they face significant challenges on a daily basis. So working through the Ogyek People's Development Program, who you also saw in the film, the litigation process actually gradually brought them together as a community through careful and regular community outreach to make sure that they understand this lengthy process, which must at times have seemed very remote, happening in a court quite far away from them in another country. The aim was to make sure they understood the process, to understand what was happening, to make sure that they actually had ownership of the process and they were included within it. Obviously, there was a big capacity for the government in such a big case like this for divide and rule. So by bringing the community together, the opportunities for that were decreased. I think it's also fair to say that litigation can offer a big platform to challenge state failings. So that courtroom, the African court, in May last year was full to the brim. And I'm told it was one of the first times it's ever been that full. But we had no idea if we were going to win or lose. And there was a significant energy, as I think you can see from the film. But actually, it was felt beforehand that the fact that this very small, numerically small ethnic minority in Kenya, the fact that their issues were being ventilated in the highest human rights body in Africa was a victory in itself, whether we won or we lost. Luckily, we were successful. So moving on from that, Jim had touched on this idea of whether litigation is for the lawyers or whether it's for the people. So I think the Ogyek case is a really good example of how litigation can be a tool of empowerment. Throughout this 8-year journey, the Ogyek's awareness of their human rights was greatly increased. And this is through the involvement and the regular outreach that we and our partner, Ogyek People's Development Program, kept going through the various stages of the litigation. Ogyek women, Ogyek men, Ogyek youth, and elders were all involved in the evidence gathering processes. And there was even a video that was produced to present evidence direct to the court. So there were regular community engagement meetings to keep them updated on the progress of the litigation and seek their views. At one point, there was amicable settlement with the government was on the table. So there was a big community consultation on whether the Ogyek wished to go down that route or not. Many Ogyek gave witness statements within the case, and there was one Ogyek woman who gave direct oral evidence to the court, which is extremely powerful. They were also given paralegal training to challenge the human rights abuses that were happening throughout the litigation, and also to monitor a provisional measures order that was issued by the court throughout the process, so like an injunction. And many of the Ogyek actually attended the African court hearing, which took place at the end of 2014, and as you've seen, also the judgment itself. So I think it's fair to say that in this case, the litigation actually really did empower the community. And I think you can also say that litigation can provide for more, support for more awareness of human rights. I was also involved in a case for the Endorois community of Kenya, who successfully brought a land rights challenge before the African Commission of Human and People's Rights. And it was their success that prompted the Ogyek to come and bring their case. But we were managed to kind of harness more awareness and build more awareness. There was arguably a lot more media attention of the issue, both locally and internationally. So I think you can see how this litigation can create awareness. I think from some of the lessons learned, the African Court OSJI case took 8 years, as you've seen. The Enderoys won their case in 2010, and unfortunately they're still seeking full implementation of the ruling. So there's a need for a really holistic, carefully developed long-term strategy from the outset of the litigation. Is there a national framework, for example, for implementation of a ruling? If not, can advocacy work alongside the litigation? So how can you use litigation to create political will or use the litigation to start dialogue? Litigation is a tool within a package of others that can be used to bring change. It can open dialogue where that has been closed down, but it really is just the beginning. Secondly, there's a need for institutional change at the local level. So, for example, to train lawyers on these rulings, to train judges, in the case of indigenous communities like the OSJI or the Enderoys, to train security forces, to train wildlife and forest guards, to engage with law schools, so that these big precedent rulings can actually have more of a ripple down effect. In terms of implementation, there's also a need to provide more support for international and regional mechanisms. So the European Court of Human Rights, for example, does have an implementation mechanism with some debate around its effectiveness, but other human rights mechanisms lack this. So I think there's a need to try and create some more mechanisms within those bodies to foster this support for implementation. There's also very pure issues around economic stability. So in the case of indigenous peoples, land concerns livelihood rights. So litigation might be a very powerful tool, but it can't meet their basic housing, access to water, and food needs, for example. So can maybe strategic litigation be combined with those who are funding strategic litigation? Can it be combined with other donors or partners? So can donors think about being a little bit more holistic in the support that they're providing? And similarly, I can imagine that those who have suffered from torture may also need counselling and practical support. So this idea of combining different ways of supporting human rights victims. And I think all these lessons, finally, need to be reflected by donors. There is a need for a very long-term, carefully thought-out support to deliver meaningful change through litigation and other processes, but not through a 1 or a 2 or a 3-year intervention. Unfortunately, it needs to be longer than that. So in summary, although there are still some lessons to be learned, I think litigation has a clear role to play in uniting and empowering communities, in changing attitudes, in emboldening others, and in creating social change. And there is still more to do. Thank you.
Thanks, Lucy. So Mandira, you're going to take us through your litigation in Nepal, and it'll be interesting to hear if you have similar lessons.
Thank you. I do actually. I actually established this advocacy forum in the midst of Nepal's conflict, basically to do litigations. When there were hundreds of people detained illegally, mostly disappeared, and subjected to extrajudicial executions. That was the time when we set up this organization called Advocacy Forum by a group of young lawyers to basically monitor police detention centers, detention facilities, and to intervene on behalf of those detained illegally. When we had started our operations, there was a state of emergencies. A number of laws were actually suspended. So the only vehicle that we had at that time was the writs of habeas corpus. And I must say that using that particular tool that we had at that time, we actually were successful in releasing hundreds of people from illegal detention and preventing them to be the subject of enforced disappearances and extrajudicial executions, which used to be the common and widespread practice at that time. I'm actually very passionate about this subject. I have been involved in a number of litigations by myself, and I could really vouch with some of the findings that have been actually brought out. How it actually diffuses the intense fear that society has in the midst of conflict, for example. It also empowers victims, human rights lawyers, defenders, legal community as a whole. And also, it also helps to bring policy and normative changes as well. But I must also flag up that these changes and impacts do actually come up with a great deal of challenges. And also victims, witnesses, lawyers involved in these kind of litigations, and human rights defenders, institutions taking up these kind of cases do have to pay quite high price as well. Today, I just wanted to share with you two cases that I have been working on for the last several years. To really unpack some of the challenges that we face, and also to show how this process actually helps us to unpack the problems that we have in the system as a whole. So it actually provides you a sort of greater space in terms of doing a lot of other advocacies in reforms. One case involves a very arbitrary arrest detentions of a very young girl in 2004. She was arrested by the security force from her home. But all the government officials refused to admit that she was arrested by the state officials. So I think unlike other litigations that we do, strategic human rights litigations actually requires to do a lot of different works, as James already mentioned. We had to do investigations by ourselves. We have to collect all the evidences by ourselves. You have to establish the facts, verify the information, protect your information, protect victims, and also worry about protection of yourself, and look for the resources to continue your work. In this particular case, despite all the lies by the state officials, we were successful to establish that she was arrested by the army. She was detained in the barrack. She was tortured to death in the barrack. And we were able to exhume the body of the girl from the compound near to the barrack. And we were actually able to establish a very detailed account how she was subjected to torture in the military detention center. When she was brought to the barracks, she was, it was like winter. Her body was submerged in cold water, and electric current was supplied into her wet body repeatedly, causing her death. And we were also able to expose how high-ranking public officials were actually involved in covering of this whole incident. So as previous speakers have already mentioned, I think the strategic litigation actually involves a number of different strategies. I think what makes the case strategic is your strategy, the strategy that you build in terms of taking up of those cases and litigation for work. So in this process, we were actually unpack how a regime was operating at that time, what we actually meant by detention in army barrack, for example, how people were subjected to torture. So it could actually, by one case, you could actually unpack a number of difficulties that you have. This was the first case that we had brought against the military officers when we were able to establish her cause of death. So we brought the case in the court. But despite the court arrest, none of the officers involved in this case were arrested. So there are actually limitations as well in strategic litigations. When the court orders are openly defied, when the whole public will and the regime actually functions under lack of rule of law, there are some limitations as well. And that is the point where I really wanted to bring my another case involving international litigations. I think this is the case that landed up here in the UK. I'm sure some of you have already heard this case, Regina versus Kumar Lama. One of the serving army officer was actually arrested here in the UK for his alleged involvement in torture in Nepal. I think that was first time after his arrest that we felt on the ground, that public officials started to feel that they could no longer safe. They are no longer safe, and they could no longer, remain above the law. There is something beyond their influence. So within the country, they could actually think that they could enjoy impunity, influencing the institutions and the outcome even from the court, or defy the court orders. But I think this case actually infused the fear, I think, in the mind of the perpetrator. So I could actually go quite a lot in terms of the achievements or the impact that strategic litigations could bring. But I really wanted to touch upon what one of the main points that James actually brought. Though we have been advocating very passionately about and have seen and able to show the impacts of these strategic litigations, I don't really see that this has actually impacted or influenced or informed the way donors support human rights work on the ground. I think we have been receiving, or we have been actually seeing this projectizations of the human rights work. And it has very negative impact in terms of initiatives like strategic litigations, because every 3 years, you have a cycle. So you have to change your priorities in order to have access to resources, for example. So that actually have very negative impact in terms of sustaining the impact of strategic litigations. And not only that, I often actually get very confused how you actually fit your achievements or your outcomes or your significance, the process, the social kind of reforms that this kind of litigation, this process actually could bring into this law frame, for example. How do you actually assess your impact, that you bring through these processes? I don't really see there is a framework that allows you to properly document the outcome of your work through these litigations. I would stop here. Thank you. Maybe there are opportunities to have more discussion during the question.
Exactly. Maybe we'll get the answer to that question. Thank you, Mandira. Okay, so we have a good 40 minutes. Who would like to start us off with a question or an observation from one's own experience? Yes, thank you. There's a microphone coming your way. And if you just let us know who you are and your affiliation as well, that would be great. Thank you.
Hi, Abigail Watson, the Remote Warfare Programme. I think a couple of you have touched upon it, but I just wondered if you could delve a bit more into it. And that is how you fit strategic litigation into a broader public campaign, especially when there's often a sense that people don't understand the law, and when it's quite a nuanced decision, they don't understand whether it was a success or a failure. And I think one example that springs to mind is the cat case, that the Saudi Arabia arms sales case, and it was looking at the rationality of the actor, but it looked as if the government had won the case, and therefore it looked as if arms sales were just legal to someone that didn't understand the nuances of what was being judged. And I wonder how you fit that into a public campaign.
Thank you. Maybe I'll take another one. Yes, the mic's on the way.
Redress. It sometimes feels at the moment like strategic litigation is the victim of its own success. Jim mentioned that some of the regional human rights courts are drowning in cases now, and we see other countries pulling out of international courts because they don't like the progressive decisions that they're handing down. What can we as litigators do to make sure that the courts and the tribunals that we rely on continue to exist and continue to be effective?
Thank you. Jim, would you like to start us off?
Sure. And just picking up on this last question, which is a really important one, I think it's a very appropriate question. It suggests that those who engage in strategic litigation have a responsibility to attend to a broader agenda than simply their own cases, their own particular causes, however challenging that may be, because, as we discussed earlier, the fora that offer them the opportunity to engage in this form of advocacy are often themselves under threat or challenge. And we're seeing that increasingly, I think, these days. And it only underscores for me the messages that we've heard from Lucy and Mandira, which is the need to join up the act of actually litigating in court with broader kinds of mobilization and advocacy, sometimes about the cause and the case, but as well about defending these systems. There have been efforts at the Strasbourg Court, of course. I think there are increasingly around the African human rights system. There have been around the inter-American system as well, where those who've been engaged in litigation see the value of litigation, even if it's not perfect or ever, have come together, are coming together as advocacy groups to try to defend, ensure sustainable resources for these institutions. But it is a parallel agenda to their own task of actually litigating. And I think it's one that we increasingly have to take on board. I did also, and I want to address the question that, or the point as well, if I could, that Mandira made about how donors support litigation. Just to mention, I think that's a critical question. One of the challenges, I think, is that I don't think we actually know very specifically to what extent what's the quantum of funding that is today going to human rights litigation, however one defines the term. I could tell you, even within open society foundations, and you said this is being recorded, so I'll be held to account for this. I don't think it's possible to know right now, down to the last euro, dollar, pound, how much support is given to litigation in support of open societies. In part, that's an issue technically of how things are coded. In part, of course, that's because many groups rightly pursue a variety of strategies for change, of which litigation is only one, and grants and payments may not get down to the level of being able to be disaggregated like that. But I think there are increasing efforts to try to quantify this, but it is a challenge. Though I would welcome, there are colleagues here, my colleague Borislav Petranov is here, who could speak to these issues probably more knowledgeably than I. I did just want to note on the donor question, there has been in the past, I mean, we've seen that donors have been reluctant in some cases to support litigation because it is seen as a controversial, contentious activity. In some ways, it's easier for donors to support public education, training, etc. Valuable activities, no doubt, often. But litigation raises questions for people. I remember years ago when I was seeking grants to engage in litigation and received a grant from an unnamed European Union member state to support our work. I was required to sign an agreement that pledged that none of the funds would be used to engage in litigation against another European Union member state. And I don't think that was unusual. So there are issues, I think, around how we educate donors to the value of this tool and how it can be used more effectively.
Thanks. Any observations?
I mean, to respond to the question about being litigators being or strategic litigation being a victim of its own success. I mean, I touched on it a bit in what I said as well about the need for this institutional support. So I've been involved in both the European regional mechanism and the African regional mechanism in a positively engaging with those bodies to make sure that they are effective processes and that where a precedent is issued and delivered, that it actually translates to something meaningful. So it's about doing it in a very positive way. I think the question around fitting strategic litigation within a broader campaign. I mean, I think the litigation I've been involved in hasn't been associated so much with campaigning. It's more with advocacy. I think it has to be, if there is a broader campaign, it's really around messaging. It's around coordination. And litigation cannot take place in a silo, or else actually can be quite damaging. So if litigation is happening and there are other campaign groups, then it really needs to be done as part of a group effort.
I think just to add on what Lucy has already said, I think there are also some issues to be considered when you involve into broader advocacy campaigning kind of work when you are doing strategic litigations. There are sometimes there are sort of barriers, to what extent you could actually mobilize the public kind of pressure or public outlet, for example, whether that could actually influence the process, you could actually restrain yourself. So there are sort of areas where you need to devise your strategies very carefully, what would work at what point of time in that particular process. So I think once you are involved into this, that's why this is a multi-years kind of investment. You would actually know what works and what doesn't in that particular context that you are working on. So in this case, we have been working for the last 14 years. The case is still ongoing. We have the court judgment convicting 3 military officers for murdering the girl in military barrack. But these 3 officers have not been arrested yet. So it's still ongoing. So it's 14 years of battle, and it's still ongoing.
Thank you. Can I just flip that around a bit in terms of public narrative? So there's trying to coordinate so that there's a kind of holistic messaging, bringing in advocacy and campaign groups. What about the situation where you're trying to diffuse public opinion, where litigation, we can see this in Europe, for example, where litigation is seen as being elitist or for particular groups, migrants, refugees. We've all seen the headlines. In your own experience, what kind of messaging can you do as the strategic litigators? If there are any thoughts on that, or we can ponder that. Jim?
I mean, I think that is a genuine problem. I mean, we've been involved, and partners of Open Society have been involved in cases where, for a whole variety of reasons, public attitudes, and particularly media attitudes, may not be very receptive to the notion of litigation. People will convene a press conference after a judgment of a regional court, say, and proclaim victory, and the question will be, well, how could you go embarrass our government in front of an international forum like that? So I think it is a serious question. I think, framing issues, and this is a challenge for, I think, the human rights community as a whole, and it's not just about litigation, though that perhaps puts it at its finest point. But how can we articulate more clearly and more effectively than we have to date how addressing human rights concerns are addressing concerns that affect most people in their daily lives? What is our notion of human rights to ensure that it is, yes, it's about accused terrorists, yes, it's about migrants, and yes, it's about many, many other people as well, to ensure that everyone defends on human rights and everyone benefits from the ability to go to court to have them defended. I think, one of the ways to do that most effectively is, as we've just heard, ensuring that the voices of those who are most directly affected, of those who have most been directly affected by the abuses for which one is seeking a remedy, are front and center in any advocacy effort, so that people can't deny this is a human being, or this is a human suffering that we're seeing here, and this is the harm that needs to be rectified. I think that is one of the most effective ways to ensure that lawyers are speaking in the courtroom as they have to, but that the voices of their clients, the voices of their communities, are prominent in public advocacy, and, as Lucy said, often in the court as well. But I should say as well, I mean, there are many, many other knowledgeable actors here. I just wanted to note that I just saw Jeremy Gilbert, who authored the indigenous land rights study that we did, is here as well, so I'm sure he'd have much to add. Lucy, of course, contributed to our study as well, so I welcome to hear what others think.
Thank you. Well, on that note, I will take a few more questions or observations. Yes, the lady? You do, yes, I'm sorry. And do let us know who you are.
My name is Tricia de Bourgrove. I'm not a lawyer, and it's going to show in my question, I'm sure. But there are huge amounts of issues internationally, but I want to go back to the American one, which at the moment, in terms of gun reform and in terms of the movement that's happened through the schools, is there an argument, or maybe it's already going on and I'm not aware of it, is there an argument for strategic legislation on human rights that are being impinged on, for example, teachers who are being told that they have to arm themselves now? Is there a sort of, could there be something like that in terms of introducing gun reform of some sort based on the impingement of human rights on people in schools having to do things against their will?
Thank you. The gentleman at the back, thank you.
Hi, I'm Borislav Petranov from Open Society Foundation. But actually, I don't want to talk about donors, but about two things that I think we need to discuss when discussing strategic litigation. And that's the question about before and the question about after. And the question about before is about the enabling environment, judges, rule of law ethos, and so on. So I wanted to ask the panelists to share some of their insights into the elements of that enabling environment, in particular in the countries and on the issues that the report of the Justice Initiative is considering, but also in Nepal. And also to spend some time maybe sharing with us one big success and one terrible frustration from the stage after, which is the implementation of judgments. We all love the moment when we win the case, we read the judgment containing large parts of our memorials, and then 10 years later, the person comes and says, you've changed your car 3 times, and I'm still living. I wouldn't ever forget that conversation with one of the applicants to the European Court of Human Rights who said, I'm still in the same, I wouldn't use a bad word here, but you've got these 100 cases and you've done well, but I'm still in the same situation. So can we talk a little bit about the before and the after, maybe on concrete examples and some insights?
Thank you. Let's just take one more for now. Okay. Lady in the front.
My name is Karuna. I'm from University of Essex. I would like to know a bit about the ethical dilemma attached. Sometimes, like we are taught in the law school that there should be continuous and full consent of the client. But then there is also this provision of friendly settlement by the court. So sometimes you might want, like you're so passionate about this case that you want the ruling from the court, but then your client, like it has been already 10 years, 15 years, but your client wants, oh, I cannot go anymore, I just want the settlement. So this kind of dilemma, like how to deal with it, or maybe you might have experienced some, so can you please share about it? Thank you.
Thank you. So we had a question about whether there's already some thinking going on about potentially the use of strategic litigation when it comes to some of the measures being proposed in the US on guns and protecting children at school. Also, very practical, or I suppose the real concrete question of what happens afterwards, and to discuss a little bit some examples, positive and negative, but also the issue of how does one think about the enabling environment when you're working out whether strategic litigation is the right approach. And what can you do to kind of create the enabling environment? And then the ethical dilemma. Who's the litigation for? Yes, the client or the bigger picture? So, Jim, I'm going to start with you again, because you're nodding a lot. So.
Well, these are great and you know, pretty deep questions and comments. So first on the guns. I mean, you know, many people point to the example of how the Second Amendment has been, the right to bear arms in the United States under certain conditions, has been successfully deployed in a manner that gives a very expansive expression to the rights of gun owners as an example of successful advocacy and successful litigation. It has been a hugely successful campaign over the course of decades from the point of view of those who've been advocating for expansive right to own and display firearms. So there's much, I think, to learn for those of us pursuing strategic litigation and broader advocacy from that experience. And indeed, there have been books written about this that I think offer some lessons for us. You know, in terms of the specific questions that you were asking, that's still going to be decided. There have been a number of litigation challenges brought against gun makers over the years. There are some recent developments that suggest maybe there is a slight path for progress opening with respect to the question of liability and the responsibility of those who manufacture firearms to ensure that they will be used safely and only by certain persons, to ensure that they can be tracked and monitored and all of those things. But that is certainly until now, the success has really been on the other side, and I think we really need to learn from what their example is. In terms of the question of the enabling environment, it's a critical question. Charles Epp, of course, wrote, a scholar in the United States, wrote a book about comparing different rights revolutions, what he called rights revolutions in a number of different countries, and identified a number of different factors as a matter of the social infrastructure and the institutional infrastructure, what's required to enable courts to be able to effect significant change with regard to human rights. He said certainly a constitution that is sufficient to incorporate rights and make them meaningful is one thing. Secondly, the judges who are capable and receptive to claims that are premised on certain rights arguments is a second. Thirdly, he talked about the need for a culture of rights among the population so that people are thinking in those terms. When they suffer harm, they are thinking, hey, there's something I can do about it, and a court can actually help address it. But all of those, he said, were insufficient. A critical fourth factor was the institutional infrastructure within civil society to generate enough well-documented and well-argued cases to move up the judicial system over time to sensitize the judiciary and to bring a series of actions over time, because his notion, as we talked about earlier, is that often one case is not enough. This really is an iterative process. And so that civil society infrastructure that is sufficiently well-resourced and capable to do this was a critical factor that is not present in enough countries. In terms of the before and after, I can only speak of, the first comes to mind is a case that I was involved in involving Roma children in schools in the Czech Republic. And on the one hand, when the court ruled in the matter that the rights of these children had been violated by being assigned to schools and classes with substandard curriculum, it was a huge jurisprudential victory. And there was a sense of reward, redemption that was felt. On the other hand, 10 years later, what material changes exist in a national system where discrimination has been systematic for decades? I think it's fair to say far too little change has occurred, which is not to say none has occurred. I think there has definitely been, on the one hand, disappointment at the process of change and how, in some ways, limited the impact of that landmark judgment was. On the other hand, I know very well that that judgment is still being used as an advocacy platform for people around the country and even beyond to say the European Court has found that I have a right to equal educational opportunity, and I can mobilize that, I can use that in advocacy with national governments and beyond. And so it is simultaneously, I think, a source of frustration and of inspiration. The final question on the ethical dilemmas, just very quickly to say, critical question. Strategic litigation is often about whose agenda drives a case. And I think one of the critical, and it may well be with a social advocacy organization that the agenda, that the reason for involvement in a case may differ from the individual client or clients. And one of the most critical things is to ensure that before anybody engages in legal action, an adequate conversation is had so that everybody understands what is your aim, what are you trying to achieve, what will happen if an offer of settlement along these terms is made, so that at least before an action is filed, people can understand what their respective point of view is, because it can get very, very tricky, and lawyers need to pay very, very due attention to that, as I'm sure you well know.
Thank you, Jim. Lucy.
Yeah, so I'll touch on this issue of implementation. So I spent the best part of 8 years working with the Envoys in Kenya to see their African Commission ruling implemented. And yeah, I mean, it was extremely frustrating at points. In actual fact, just before the successful decision was delivered, there had been a new land policy, which was very much in line with what the African Commission ruling said itself. So we were extremely hopeful. And immediately after, within the first year of the ruling, there were various politicians and the lands minister who declared that they were going to implement this ruling. But then it was about how to kind of create that political will. And we tried so many tactics, and I think that it's fair to say that the ruling is now partially implemented, but there was a whole wide-reaching strategy of national advocacy, of international and regional advocacy. We worked with the African Commission to develop more of an implementation mechanism. We had the first ever hearing on implementation between the Envoys and the state. And we asked the African Commission who did it to release a resolution calling upon the state to implement, and there was other work in other bodies such as UNESCO as well. It's really, really hard. I think it's fair to say that we also learned from that process. So when the OSJI case came to be decided, we actually asked for a separate ruling on reparations. So the judgment that was delivered last May is only on the violations of the African Charter, and we've been a lot more detailed in what we've actually asked for in terms of reparations. In the Envoys case, all that was declared was restitution and compensation. I mean, how do you quantify compensation for a community of 60,000 for the lack of access to their land for 40 years? How do you possibly do that? There's no mechanism, and that's what we also kind of struggled with for quite some time. So it's also about learning and trying to get these much more kind of specific rulings from courts about really what steps need to be taken to implement, and have they been satisfied. On the ethical dilemma, I mean, it's something that's come up in some of my cases. It came up, as I mentioned, in the OSJI case, quite unexpectedly. After we'd had the merits hearing, the government offered amicable settlement because Kenya had a different constitution and it was a completely different setup, etc. Now, I knew that we couldn't really take that at face value, but I had to work very closely with the OSJI to find out what they actually wanted and whether they felt they could take it at face value as well. And in actual fact, they're the ones who've been caught in this struggle for nearly 100 years, not me. And that they were driven by themselves, and they went down this route for a few months. It was clear that amicable settlement was not going to go anywhere, and so we went back to the court. But it is a real dilemma. At the same time, I do see that litigation can sometimes, in some circumstances, be a way to open dialogue, and that it shouldn't always just be seen as a mean to an end. It can be a tool to try and encourage mediation, and I think we shouldn't forget that.
Thank you, Mandira.
I think before and after, I think this is the challenges that we face. From my personal experiences, in a very difficult time when you have very repressive regime, when you are under conflict, state of emergency, the scale of violations widely spread, very intense fear. I think even in that context, for example, in Nepal, litigation did help us to expose the regime and set a sort of a stage for international scrutiny, greater international scrutiny. For example, the documentations that human rights organizations were able to do in Nepal, and also through some litigations. For example, when we were bringing all those cases of habeas corpus, that would actually allow you to have very official kind of record of number of people reporting disappear or detained illegally, for example. So when it actually compiled in a very systematic way, could actually paint a very compelling picture as well. So we, using our documentation work, we actually contributed significantly in terms of having more international scrutiny on what was going on in Nepal, which ultimately helped us to, build the confidence of human rights defenders, human rights organizations, and civil society movement as a whole. That would ultimately resulted in, political change in the context. Of course, it will be too naive just to give all the credit to this, but it contributed significantly to that process. Then I think we were very hopeful that with all the political change that we have entered into a sort of era where we could actually start discussing about the nitty-gritty of justice process, for example, and addressing all those violations that were committed, because all those victims were still waiting for those days to come. But unfortunately, that is the point when you are actually in a very difficult kind of phase, especially if the nature of conflict resolution is by agreement, for example, if it is a sort of pacted transition, then those who have interest to avoid accountabilities are there sharing the power, and they are the one to prevent any reforms to happen, because that would actually impact their interest as well. And that's where we are actually struggling now. We, through all these cases that we have been working on, they are still there in the court. In a number of cases, there are pending arrest warrants as well. So that actually makes the issue alive and it informs the discussions that we have on transitional justice, for example, how we deal with the legacies of the past. For example, through the case of universal jurisdictions and other international litigations that we have been doing, there is this knowledge that there is a sort of jurisdiction beyond Nepal as well that also informs the process on the ground. But how do you actually get a sort of impact in terms of addressing that cycle of impunity is the battle that we still have to win. And this is the continuous battle that we are in.
Thank you. Any more questions? Sorry, I'm not ignoring, I just feel I've neglected this side of the room, but there are no hands there. So yes, we could take these two, please.
Hi, Jason Brickhill, previously of the Legal Resources Centre, now University of Oxford. My question is for James, but it's prompted by Mandira and Lucy's presentations too. I think this study by the Open Society Justice Initiative really does contribute to the existing literature. It adds massively. And I think it corrects the skewing of the literature and the understandings of strategic litigation towards North American understandings that has existed until now, especially given the dominance in the literature of Rosenberg, McCann, and that stream of literature, which has informed how people think about strategic litigation. But I just wanted to think about where to from now on. This is a massive study, 12 case studies, 11 countries, many hundreds of interviews. But I wonder if there's still further work to do in terms of teasing out the comparative angles of what's possible in different legal cultures, different legal conditions. I think this study goes a long way to answering some of those questions and filling gaps in the literature. But I wonder if that's the area that needs to be further explored following this work.
Thank you. And the lady behind.
Hi, Joanna Whiteman from the Equal Rights Trust. I have a comment and a question. Equal Rights Trust, just to contextualise my comment, is an international NGO which looks at combating discrimination and advancing equality. And we use a number of strategies, but strategic litigation is one of those. I just wanted to kind of share the panel's experience in terms of the projectization of human rights from a donor perspective and the challenges that we face from that. I mean, what's the magic answer to the log frame question? I don't know. But I also wanted to just to kind of also confirm that from our perspective, we have had donors where we will put in an application for funding, and we never just do strategic litigation as a project. It's always part of a holistic approach, but we do sometimes have donors come back and agree to fund the project with the exception of the strategic litigation element. So I think this is a real problem. 3 basic thoughts that I have, but I don't have any answers. I wish I did. One is, I think that a part of the problem is the lack of funding for monitoring and evaluation of the impact of strategic litigation. And I share Jason's view that the OSJI reports are really, really critical. And I think that all organisations like ours should be using these to make, I think they do help us to make the case to donors. I agree with Jason, it's an important thing for us to talk about where next, that they're a starting point. I think that the point that was made about the need to show that that strategic litigation is part of a holistic effort, I think increasingly we're finding that we need to make the case to donors that it's not incompatible with collaboration with the government, and a much more, it's always tied with advocacy, and that can be a friendly process. It doesn't have to be combative. One small potential opening for some donors is the Sustainable Development Goal 16, recognising how central rule of law and institutions are to the achievement of development. And we're coming from a human rights perspective, and that's the language we usually use. But I think there's potential. I'd be really interested in others' views, but I think that there's potential for some conversation with development donors now that we have this clearer link made. That long comment, my question, therefore, in that context of human rights projectisation is, I'm curious to know, particularly in regard to the OSJI case, but other cases that the panellists have talked about, how successful have you been, and how have you raised funds particularly for the implementation of phases of your work? Thank you for bearing with me.
Thank you. Okay, so is there more work to be done in analysing how these cases are handled around the world and drawing out further lessons? And then we're back to donors again, which is, exactly a very pragmatic issue that anyone has to address. Mandira, do you want to start this time?
Straight on this question, because this is, as I said, one of these cases that I mentioned, that we have been working for the last 14 years, and the case is still ongoing. So from the project point of view, it's a failure project. It's a failed project because there is no time-bound kind of result that you could produce, for example. And also, so what, there is this convictions from the court, but which is not even implemented, right? We always struggle in terms of getting funding for the kind of work that would require many years of involvement. And working with these kind of cases, building that from day one, we could actually see the value of it, how important it is to take it to a sort of logical end, not only to have a final verdict. The process around that would actually allow you to gain so much that you wouldn't be able to have then providing a lot of trainings or capacity building kind of work that we generally see some of the donors being very interested in. But that's the challenge. The way we present it, in a way, it is holistic. So it's not just like doing litigation, because it involves a number of other activities and interventions. So this is how we were able to get some support, but not always. So you actually have to rely on a lot of pro bono kind of lawyers. And I just want to flag up that, on this particular case that I mentioned, we had the convictions from the district court, and none of those convicted officers have been arrested. Instead, Army headquarters has filed another writ in the Supreme Court, claiming that this case has to be void, this decision has to be void, claiming that the case actually comes under the jurisdictions of the transitional justice process. And we actually do not know what is that transitional justice process. We have not actually defined that. We have Truth Commission. Truth Commission has also been caught into this controversy because of the legal framework on which the commission has been established, because the Supreme Court has found that number of provisions in the Act setting up Truth Commissions actually violates Nepal's constitution and Nepal's international obligations. and has actually ordered to amend a number of sections in the Truth and Reconciliation Commission Act. Though the Act has not been amended, those provisions in the Act has not been amended, yet government used this as a sort of excuse to avoid any kind of scrutiny and justice for conflict cases. So the argument of the army is to actually avoid this decision because it happened in a particular context and it has to be looked by the particular kind of mechanisms, i.e. Truth and Reconciliation Commission. The second, they also claim that there is this principle of double jeopardy because we already court-martialed these officers. So in the process, we came to know that there was this court of inquiry, and then these officers were suspended for 6 months or whatever, 50,000 Nepalese rupees of fine, or So there were this internal kind of process. These sort of issues actually were raised quite early on as well, and we already settled this in the court. We actually argued in the court. Court had already said that there is no applicability of principle of double jeopardy because these guys were not tried for murder. They were tried for not fulfilling their duties when they interrogated the girl, when they used improper techniques of interrogations, the terminology that they used. And the court had already said that this is the case of murder, and it actually does not come under the jurisdiction of military court. And our act, the military act, is also very clear on that. So despite all this case, the writ has come back again in the Supreme Court, and the Supreme Court has registered this, and there is a hearing. And you have to see the appearance of the lawyers, for example. They have a sort of impressive bunch of lawyers representing the army, and we had to rely on very junior pro bono lawyers defending, and how the whole approach, the strategy of intimidating these lawyers. So the whole strategy actually, impact the end result of the case. I'm pretty sure. So how, like before and after, again, I think these sort of cases, I think you need to sustain until I think their power is weakened. So you could actually bring it back and actually open a service space. You really have to continue this effort until you have some space to open up. And how you sustain that is a great challenge. I think this is the struggle that we are in. I'm sorry, I don't have a very good promising answer, but
yes. Well, I think you're just highlighting it again. I mean, have you had a single donor that stayed with you throughout?
No.
No. Okay, there you go. Lucy?
Yes, so the point about donors, so I mean, the specific question around donors to support implementation of the OSJI case, we were actually very successful in getting some support immediately after the judgment, but only for 1 year. So I can't see the implementation is going to be achieved in 1 year. So maybe, we'll just have to kind of keep going and going. I mean, that was more of an advocacy, capacity building project. Although obviously there is some litigation still involved there because the case is still before the court in terms of the reparations. But I mean, all the way through that case, that 9-year journey, it was just a patchwork of different donors here and there, like Mandira is saying, and a number of times that I have to say in a report to donors, no, we're still waiting for the judgment, or we're still waiting for this stage, and you can only say it in so many ways, and what actually are those kind of measurable objectives as well, like we're saying about fitting it into a log frame. It is really hard. I've also been involved in some a wider program in Mauritania, whereby, so this is challenging the non-implementation of an anti-slavery law. So there is litigation at the national level, there is litigation at the regional level, but there's also much wider reaching capacity building and advocacy support, including training for judiciary, training for prosecutors, training for police, and those who should be enforcing the anti-slavery law at the local level. And there's 2 donors involved there who actually have seat do have a kind of longer term vision, and also the way that the whole program has fitted together makes sense, because it's looking at the whole picture as opposed to just the litigation or the advocacy or the capacity building of the partners and those on the ground. So that remains to be seen how successful that will be. It's still only halfway through, and hopefully will continue for a bit longer. But that's another way of you can kind of pull things together.
Thank you. Jim, we started late, so we still have a few minutes. So, yes, you
well,
can
I'll be brief, not to hold everyone. But so the short answer to is further research and study needed? Absolutely. And I'm glad that this is seen to be the studies have seen to be a useful contribution to the discussion, but by no means is it the end of the discussion, of course. You know, in terms of the challenge of securing donor support for litigation, for research about its impacts, et cetera, it's a real challenge. I think one of the problems is that there's really, there are at least two sectors of the donor community. One large sector that really hasn't contributed to litigation and it's not on their agenda, and a smaller group of donors that has. But a challenge there, I think, and I'm just one voice, I'm interested in what others think, is that a number of those donors feel as though litigation is a tactic that has been tried, and it's kind of caught up in the general critique of the human rights movement that is very prevalent today, in which, as we all know, the impacts of that movement more generally are being questioned in a serious way, and litigation is part of that. So some donors, I think, are suggesting that, well, litigate, you know, give me some new taxes, give me something that really has impact, that really works. So it's a challenging uphill battle, I think, and that's certainly not true of everybody, I recognize that. But I really think one of the most effective ways of dealing with that is through just explaining, and you, all of you here are able to do that, how the work that you are doing is achieving value for the people that you are serving, and making clear that there is demand for legal action in addition to a variety of other strategies that's coming not from necessarily only from bar associations and groups of lawyers and judges, but it's coming from the very people who are suffering rights violations whom donors purport to want to support. And I think, you know, to the point that the picture is emerging of a more variegated global effort at litigation than simply the traditional narrow North American or Anglo-American picture that some are more familiar with, I think it is important to underscore that this is a global movement, or it's certainly a series of movements that exist north, south, east, west, that people really feel as though, notwithstanding its flaws, notwithstanding its challenges, there is real value to be derived from litigation as a means, one means, of addressing the problems they face. So telling that story, I think, is very, very important.
Thank you, Jim. Well, I think that's a positive note to end on. Thank you all for coming and for contributing to this discussion. I'd also like to thank again Open Society Justice Initiative for helping us to put together this meeting. Please do take a copy of the executive summary if you haven't got one already. And that just leaves me to thank our speakers. Thank you very much. You all deserve a drink. So please join me in thanking them, and do join us for a drink upstairs. Thank you.